All right, guys, let's get into this story. This is a really crazy story, and I can't even believe the outcome. There we go. So, today we're going to be talking about Karen Reed, and this is a case that I have actually got really into this past summer, and it ended in you'll find out, but we're going to go through a little slideshow that I built this morning, and I want to try to start doing this for every single case that I cover. So, who is Karen Reed? The background of Karen. Karen grew up in Taunton, Massachusetts, and Blacksburg, Virginia. She graduated from Bentley University with a bachelor's degree and a master's degree in finance. She worked as a financial analyst at Fidelity Investments and was an adjunct professor at Bentley. Adjunct. Guess I should have read this before. So, what are Karen's charges? Reed is charged with second-degree murder, manslaughter, and leaving the scene of a crime. The victim is John O'Keefe, and we're going to learn a little bit about John O'Keefe next. Who is John O'Keefe? He was a Boston police officer, a father to his niece and nephew who lost their parents tragically, Karen's boyfriend at the time of the incident, a son, brother, and a friend to many. And to anyone questioning why he became the father to his niece and nephew, his sister died of cancer, and then not too long after that, the boyfriend or husband of his sister died as well. So he took both his niece and nephew in. Now, prosecutors allege that Karen intentionally hit O'Keefe with her SUV after a night of drinking. We're going to get into everything when it comes to all of this and my stance on what I believe. And then Karen's defense argues that she was framed and that O'Keefe was actually killed inside another Boston police officer's home. They also claim that investigators targeted Reed because she was an outsider. Now, we ended trial in, I want to say it was like in July. It had to have been in July. No. It was in June. It was before my sister moved. So Karen's trial began in April. It's right here in front of my face. Reed's trial began in April 2024 and ended in a mistrial in 2024. Oh my God, it was so long. Prosecutors will retry the case in 2025. So they're actually going to retry the case January 27th, I believe, of 2025. But there are several hearings scheduled to see if they can have a continuance until April 1st. Judge Canoni is going to be on the case again. And there is a new prosecutor that was hired to be on the case. He's basically the lead prosecutor. And Adam Lally will be with him. He does seem a lot more organized and level-headed than Lally was. But now I'm going to get into my thoughts on the case. Okay, so these are my thoughts and my thoughts only. And one amazing thing about, anything is that you can have your own personal opinion on what you think about any case or anything. That sounded very condescending, but I'm not like that. I am not the channel that's going to be non-biased. Unless I truly feel like I don't have enough evidence in a certain case to not have a true opinion. I believe Karen Read was innocent or is innocent. I believe that she was framed. And I am not one to believe in those types of things. In fact, when I first jumped in on the case, maybe it was like halfway through trial. I actually watched a few pre-trial motions, and I can remember seeing Jackson talking about Karen being framed, and I can even remember at one point just being like kind of chuckling and being like, what? There's no way somebody actually really thinks this. And then I began watching the trial probably 2 weeks in, and this trial lasted so long. I've never seen a trial last this long before. I believe there was like over 100 something witnesses. It was very, very long. I actually was flabbergasted that it ended in a hung trial or a hung jury. They were deadlocked. I believe they came back. The jury came back 3 times total. Just completely deadlocked, and I was devastated that it was not a not guilty verdict, but also was like, I didn't think they were going to retry her. I was like, there's no way. There's absolutely no way they're going to retry her. But they are. So I believe Karen is innocent. I am into the Free Karen Read movement. There was beyond evidence, like so much evidence with Jen McCabe, Brian Higgins. I mean, there was so much reasonable doubt that it was, I don't even think the defense needed to like present their own theory, but them doing so made it make more sense. And I know that some people are like, oh, if they would have just focused more on reasonable doubt, they would have probably gotten a not guilty verdict the first time around. I don't know, because Jackson and Yannetti and Miss Little presenting with what they believe happened truly pokes so many holes. It just really made you think. And it's like, holy shit, wait a minute. This could actually happen. And that to me is so much reasonable. There's just so much reasonable doubt. So many phones being thrown away. So many texts. So many Google searches. How long does it take to die in the cold on Jen McCabe's phone? What was it? 1 something in the morning, 2 something in the morning, and then it was deleted. And see, the thing is, these witnesses like Jen McCabe will be like, whenever the Cellbrite data makes her look good, she agrees that it's correct. But when it incriminates her, she's like, oh no, I didn't do that. And that's not how this works. So needless to say, I am chomping at the bit for this trial to start again, but I do know that I have a very strong feeling it's going to take till April. But in the meantime, I thought we could just do a little recap on it. After this, I plan on finding some videos to just kind of like highlight some of the facts. And if you're not new to this, or if you are new to this case, it will, give you some information about who, what, where, when, why. And so yeah, if you like this kind of content, go ahead and drop a follow. like the video and share with some friends, and let's get into it. All right, so I'm going to see if this has some good facts in it for us.
Commonwealth versus Karen Reed, 22-1117.
John O'Keefe was a 46-year-old Boston police officer. He was off duty on January 29, 2022, when he was found lying in the snow outside a home in Canton. O'Keefe had grown up in Braintree with his older sister and younger brother. The sister, Kristen, was married to Stephen Furbush. Stephen and Kristen had a daughter and son. After Kristen and Stephen passed away, O'Keefe became the guardian of his niece and nephew. O'Keefe moved into the children's home and became neighbors with Matt and Jen McCabe and their 4 daughters. O'Keefe and the children moved to 1 Meadows Ave in Canton. Chris and Julie Albert lived on the same street with their 3 sons, Chris Jr., Colin, and Dylan. In 2020, O'Keefe started dating Karen Reed, who later started living part-time with O'Keefe and the children. O'Keefe remained friends with the McCabes. O'Keefe introduced Reed to Jen McCabe, who both have multiple sclerosis. Colin Albert and Allie McCabe are close friends. Chris Albert has a brother, Brian, who was also a Boston police officer. Jen McCabe has a sister, Nicole. Brian Albert Sr. and Nicole Albert are married and have 5 children, including Caitlin and Brian Jr. In 2022, Brian and Nicole Albert lived at 34 Fairview Road. Which is where John O'Keefe's body was found.
Okay, so just a warning, the following video contains material that may be harmful or traumatizing to some viewers. This video is 7 minutes and 29 seconds long.
Big break in the case of a Boston police officer found dying in the snow during the blizzard. John O'Keefe was found dead outside of a home in Canton over the weekend.
And the big shocker, his girlfriend from Mansfield now charged with manslaughter.
Could I have hit him? Did I hit him?
That's what the prosecution alleges Karen Reed told a friend after dropping John O'Keefe off at a home on Fairview Road in Canton, where he was later found in the snow. The courtroom was filled with Boston police officers and the families of both Reed and O'Keefe, who listened as the assistant Norfolk district attorney laid out this timeline. He said the two were going out drinking at a couple of bars on Friday night before deciding to go to that home on Fairview Road. Reed dropped O'Keefe off there early Saturday morning, did a 3-point turn, and left to go home. While home, Reed's lawyer says she tried getting a hold of O'Keefe.
At 4:30 in the morning, my client is placing multiple calls to the victim in this case, to her boyfriend, wondering where he is, why he hasn't come home.
When she couldn't get in touch, she went back to Fairview Road to see if he was there.
At the time, it was snowing heavily, creating poor visibility.
O'Keefe was found around 6 Saturday morning and later pronounced dead at a hospital.
She discovered the victim in the morning. She observed him lying face up, snow on his legs, eyes swollen and blood coming from his nose and mouth.
Prosecutors say red pieces of plastic that match the missing pieces from the broken taillight on Reed's car were also found at the scene, while the defense argued manslaughter charges are not justified.
There was no criminal intent. This was not some random stranger. This was my client's boyfriend, somebody with whom she was in love.
We were happy, having fun, laughing, just very normal.
Her attorneys argued that evidence being withheld from them will show that the people inside the home are responsible.
Instead of finally investigating the people who had a motive to kill John O'Keefe, who beat him and left him to die in the cold in a blizzard, the prosecution has chosen instead to dig their heels in. This will not end well for them.
The attorneys have filed motions to get the phone records of homeowner Brian Albert and his sister-in-law, Jennifer McCabe.
Why did Jennifer McCabe Google search how long to die in cold at 2:27 in the morning, 3.5 hours before she would have any reason to believe that John O'Keefe was dying in the cold in front of Brian Albert's house?
The defense argues Albert, who has a history of fighting, attacked O'Keefe along with his 90-pound German Shepherd. The Commonwealth argues witnesses, forensics, and every piece of evidence to this point prove Reed hit O'Keefe with her car.
I'm just a little confused as far as are they in the conspiracy, or are these people sort of let out of the conspiracy because they say something that doesn't further that conspiracy? If they're all in the house, and Mr. O'Keefe comes in the house and gets attacked by a dog and then gets dragged out to the bottom of the lawn and left there for dead, then why do they all testify that no one came into the house?
What Reed's lawyers were claiming in court today is that there is corruption in this case that might include Judge Cannone. Alan Jackson, Reed's attorney, pulled out a text message that he says Boston Police Detective Sean McCabe sent to a reporter claiming that McCabe had ties to the judge. Reed's defense requested the judge to step down. She denied that motion and any ties to anyone in this case.
I've never interacted with him, and I certainly never have socialized with him.
If you look behind me, you can actually see the barricades set up right now surrounding the courthouse. It's all because of the protests that we've seen in the weeks leading up to this trial. Reed is accused of backing her SUV into her boyfriend, Boston police officer John O'Keefe, and leaving him to die in a 2022 snowstorm. Reed pleaded not guilty to the second-degree murder charge. Her attorneys claim she's being framed as part of a cover-up. The case has drawn a lot of attention, especially from supporters of Reed. That's why state prosecutors have put restrictions in place like that buffer zone that I mentioned. Some argue it's against their First Amendment rights.
Commonwealth is calling it a buffer zone, but they might as well call it a restraining order against the citizens of Massachusetts.
I think she's very unjustly been treated by the state of Massachusetts.
Karen Reed could be any one of us. Thank God she has the money and the means to fight this. But if it was us, one of everyday person, we'd be in jail by now, and you wouldn't even know about this.
What has this process been like for your family?
It's been hell. It's been 26, 27 months of hell.
She said, I hit him. She repeated it. There was a woman standing across from her who I believe at that point said, you're hysterical, you need to calm down.
Just something like, he's dead.
All I recall her saying was, is he alive?
Cross-examination of firefighter Flamati was contentious, as the defense asked him where he was in a video, why his claims weren't in a report, and what he said at the hospital.
You directly told the doctors and nurses that there was a question about whether or not he was hit by a vehicle, right?
Yes.
Have you ever said that in any context, either to the police or in a grand jury before today?
I don't recall.
Boston police officer John O'Keefe's family emotional in court today as the 911 call from the morning he died was played.
I want to do that on side.
How many pieces of taillight did you find on or around that property?
That morning, none.
Reed's attorneys, who allege a cover-up, also questioning why inside the home wasn't searched thoroughly that morning.
Nobody put John O'Keefe anywhere but where he was found.
The defendant kissed me.
And how did she kiss you?
Not like a friend.
ATF agent Brian Higgins, who had an office at the Canton police station, taking the stand in the Karen Reed murder trial.
Defendant responded, "You're hot." I responded, "Are you serious or messing with me?" Defendant responded, "No, I'm serious."
Prosecutors showing pages of flirty texts between the two. The same month, Reed's boyfriend, John O'Keefe, was found dead at 34 Fairview Road in Canton.
Not proud of these text messages. It is what it is. I'll take responsibility for them. But, you know, John was a friend at the same time. And if they were at the end of the relationship, they were at the end of their relationship. But I wasn't going to have somebody utilize me.
On cross-examination, Reed's attorney pointing out she didn't answer Higgins' text at the bar hours before O'Keefe died.
Well, why are you ignoring me?
It's not correct.
Well, am I chopped liver? So where's your phone?
I do not have that phone anymore.
You've destroyed that phone, haven't you?
No, I threw the phone away.
Well, that's destroying the phone, isn't it?
I had every right to do that.
I'm not sure if it's in this document, but I can tell you today with 100%.
This is exactly
clarity. She said, I hit him.
Brian Higgins, which is the man who just said that he threw away his phone. Who throws away their phone? I don't even think millionaires throw away their old electronic devices. Nobody does that, especially when there is an active investigation against you and your entire group of friends. The only reason that you would have to throw away a device, no one throws away their phone. It's just, and it just goes beyond that. If I can find anything else on this that is not copyrighted, I will add it to this.
Her boyfriend, Boston police officer John O'Keefe, were bar hopping on a snowy night in Massachusetts. At the end of the night, they were invited to a house party at the home of a fellow officer in Canton, Massachusetts. When Karen and John arrived, Karen did not exit the car. John did. From that point forward, there are two very different versions of what happened. Prosecutors say Karen was mad at John and purposely struck him with her car and left him on the ground to die in the snow. But Karen and her defense team say John went to the party. Something terrible happened inside the house, and his body was placed outside, where he was found dead the next morning. Karen has been charged with murder, but claims she is the victim of a big cover-up by police. The battle inside the courtroom and outside the courthouse has been intense. Prosecutors insisting Karen Reed is a murderer, while she insists it was someone inside the house that night who is responsible for what happened to her boyfriend, John O'Keefe. Tonight, we bring in our own independent experts to examine the evidence in this case piece by piece as we try to figure out what happened to Officer John O'Keefe.
So my wife got me this weird new kitchen knife as a Christmas gift. God.
I'm Vinny Politan. Great to have you with us tonight here on Closing Arguments. And let me tell you, things are brewing up in Massachusetts in this case. This is heated, to say the least. I mean, anytime we do this story or anyone does this story, everyone is reacting, sending emails, texting. Everyone is just so hyper-focused on everything that transpires here. And then something extremely unusual happened. We had an angry DA who posted a statement, carefully crafted statement so he doesn't violate any ethical rules, which he did not. But a statement nonetheless where he is angry at those who are going after innocent victims of, members of the family and witnesses in the case. A lot of it happening on the internet, some of it happening outside the courthouse, on the courthouse steps. But he posted a video and he was extremely angry about the way these witnesses and the victim's family and friends were being treated by people, a lot of them local, on the internet, talking about this case. And say they are 100% innocent. They are presumed innocent, just like every criminal defendant. But that's what makes this case so different, is that it seems that the shoe is like on the other foot to a certain extent. It's rare that we see people protesting the prosecution at the courthouse. A huge crowd of people led by the man you see right there. He was on the show. Goes by the name Turtle Boy. Local social media personality with a growing following.
If you don't follow Turtle Boy and you side with the free Karen Reed, go follow him. He's like always posting stuff and he has so much knowledge about this case and just, he's awesome. I am a Turtle Boy fan.
Talking about this case over and over again and kind of striking a nerve with a lot of people. I had him on the show to explain, why are you protesting? Why are you doing this? He's not connected to anyone in the show, but he said, in the trial, but he said he thinks there's an injustice here. But the people that he's protesting are getting a little angry and fed up, and it goes back and forth, because they all believe that Karen Reed is a murderer. He doesn't. Neither does Karen Reed. As a matter of fact, Karen Reed believes that she's a victim in all of this, a victim of this police cover-up. Now, the DA was angry about that too, talking about what, a conspiracy between all these different departments and all these different people, what, to frame her? But that's what she believes. That she did nothing wrong, and it was someone in that house. Remember, it was an after-hours police party that night. So the defense has been on the offensive. It's not just that they're saying, no, they can't prove this case. They're saying, no, we know something happened inside that house, and we need to get that evidence. I mean, and you'll see in the trial, and we'll show this jury. The defense is even saying there shouldn't even be a trial. They think the prosecution should just drop the charges. That's not happening. I mean, I heard the DA. He's seen all the evidence. He believes his evidence is strong enough to win this case, and he's convinced. But the question is, what does this evidence actually show? Now, some of it has been released through statements in court hearings and everything else, and we're going to go through that evidence piece by piece tonight. Going to bring in our own experts to try to get a better understanding. Because through all the chatter and the noise between the protesters and the defense attorneys and the prosecutor and everyone talking, we're going to just try to shut that out for a night and focus in on some of the evidence, get an independent look at it to see what it means, what questions still need to be answered, and try to get a little closer to what the truth may be in this case. But it may be very difficult, because the more you look at it, the more you're like, well, I don't know what exactly is happening here. So let's go through some of the facts of what happened that night and who was involved. So let's bring in our friend in Los Angeles, California, senior reporter for DailyMail.com, the host of Daily Mail Crime on TikTok, and a victim advocate for Project Cold Case, Caitlin Becker, back with us. Caitlin, great to see you tonight. Let's start first with John O'Keefe, Officer John O'Keefe, the victim in all of this, and Karen Reed. I mean, I'm trying to get a better understanding of the nature of their relationship and who they were and what was going on in their lives. What's your understanding about who these two are, what was going on generally in their lives?
Well, Vinny, they have a really long history. They had actually dated in their 20s and lost touch and then reconnected more than a decade or so later through social media and then started dating again. So they have quite a few years, under their belt, just being in each other's lives and being together. And their relationship had transpired in a way where things were good for a little while, and then they seemed not so great. And in the weeks leading up to O'Keefe's death, it seemed that their relationship had gotten a little bit rocky. There was a fight around New Year's Eve. There were some issues with the family and how O'Keefe took care of his sister's children or his relatives' children. At first, she loved that, and then it became kind of Karen Reed's responsibility. So things do seem a little rocky by the time we get to the end of January.
Okay, so let's go to the end of January and let's talk about that night. We've got a little bit of a timeline I want to walk through with you to try to get a better understanding of what generally was happening and what they were doing. We start at 7:37 p.m. John O'Keefe arrives at C.F. McCarty's in Canton, and then at 8:51, a little more than an hour later, Karen Reed arrives at C.F. McCarty's. And my guess is C.F. McCarty's, like a lot of the bars up there, it's where people go to, drink. Looking at it, looks like a nice, like a pub, right?
Mm-hmm. Irish pub.
Nice Irish pub, and it's a night of. It seems like these two are meeting. They didn't go there together. Do we know? I mean, generally just out for drinking, right? Were they out to eat? Were they drinking? Were they celebrating anything or any of those? any of that information?
It appears they were doing a lot of drinking, Vinny. Some surveillance footage from inside the bar shows in the course of about an hour and a half, Karen Reed having something like 6 or 7 drinks. And this was the first bar they went to. And then they left and they met up with friends at a second bar where they presumably had more drinks. There was a lot of drinking happening this night, and the intention was clear. Some more, because at the end of that second bar, the group was going to go back to have a little after hours party back at one of their homes. So there seemed to be quite a bit of drinking. The first thing that sticks out to me is there is no way, if these drinks were alcoholic, which we assume they were, that Karen Reed should have been behind the wheel of a vehicle. We see her at the bar, several drinks in the night.
You guys, don't make fun of me. I used dry shampoo yesterday for the first time in a long time, and it's just like coming out as flakes. Just thought I'd share that.
There's absolutely no reason she should have been driving a car.
Yeah, and you know, when we first looked at this case and this story, you would think that that's what it would be all about, right? A drunk driving or an alleged drunk driving accident, but that's not the way it's turned out here. All right, so as you mentioned, at 10:40 p.m., Karen Reed and O'Keefe leave together. They leave CF McCarty's, and about 15 minutes later, they arrive at the Waterfall Bar and Grill, also in Canton. This is interesting because they're hanging out in Canton. He's a Boston police officer, but where all this is happening, it's not Boston, and it's not a case that was investigated by officers that work with John O'Keefe.
No, this isn't these are suburbs outside of it. But I do know that up in this community, the law enforcement group is not a huge, widespread thing. I mean, they have a lot of officers up there, but you know how small these, law enforcement can be, and everybody kind of does know everybody. I can't wrap my head around the fact that a bunch of police officers were around and allowed someone who may or may not have been absolutely hammered get behind the wheel of a car. That's still.
That's because they all do it too. And that was in the complete trial. Higgins admits to drinking and driving. The other fucking guy, Chris Albert, or what? Both the Alberts, basically. So yeah, why would they say anything? They do it too.
Still sticks out to me as being an issue. It also calls into question for me whether or not Karen Reed is a reliable narrator of her own story that night, assuming she was intoxicated.
Yeah. Like, how intoxicated was she? What does she remember? What does she not remember? But again, the charges here are that she did it intentionally, that this was no accident. 12:14 a.m., John O'Keefe texts Jennifer McCabe, "Where to?" Jennifer replies with the address of her brother's house on Fairview Road, which is where this so-called after party is going to take place. 12:31 a.m., Jennifer McCabe texts John O'Keefe, "Hello," when he sees what she believes is Karen Reed's black SUV at the residence. This is interesting. So Jennifer McCabe, who's inside the house, I guess perhaps or apparently sees Karen Reed and John O'Keefe, at least the car, arrive in front of this home.
That's exactly right. And another text that comes through around this time from Jennifer McCabe is basically giving them directions as to where in the driveway to park. I think it's something along the lines of, pull behind my car or pull behind this vehicle. So presumably the people in the house see that they're there in the driveway looking to park, and the people in the car presumably know that this is the house that they're going to because they were directed where to park. This moment in the timeline is where everything goes off the rails for me, Vinny, because the people in the house say that he never came inside to this party. They never saw him. And then you have Karen Reed saying he got out of the car, went in the house, never came back, and never answered her phone calls. I can't believe that no one went outside ever to see where he was. if you see me pull up, Vin, outside of your house and you're expecting me to come inside and all of a sudden I disappear and my car disappears, wouldn't you be concerned? And on the same token, if you and I are driving to a party and you get out of the car to go inside and you don't answer my phone calls or come back to the car, I'm gonna get concerned. It didn't seem like anyone was concerned until tomorrow.
No, till the next day. And so let's get to 12:40 a.m. Jennifer McCabe texts John O'Keefe, pull up behind me, and says she then saw the black SUV move from its initial place to the left side of the property. This is very specific. 12:45 a.m. Jennifer McCabe texts John O'Keefe, hello, and then observed the black SUV drive away. So if she's seeing it drive away, does she see it run?
So if she saw it drive away, then why did she Google search house long to die in cold? At but we'll find out what time. I believe it was around 1:26 or 2:26.
John O'Keefe over. She's seeing a lot, but she's not seeing that.
She's seeing a lot. She doesn't see John O'Keefe get run over, but where she claims she sees the SUV sort of back up and move is between a fire hydrant and a flagpole, which is what she says. And that will become very important when they find his body the next day near this fire hydrant and flagpole. So she might have actually witnessed him getting run over if he was in fact run over in that moment and just not have been able to see the moment of impact because of how she was looking out the window and how the car was placed. And as you said, my first guess was perhaps this was an accident, because perhaps allegedly she was drunk behind the wheel. Maybe she just backed up, didn't notice she hit him, and then drove off and had no idea until the next day. But as you said, the accusations are that there was a fight and that this was done intentionally and that Karen Reed left him for dead in the cold, knowing that she had run him over.
And we go back to the timeline now, it gets even more interesting. At 4:53 a.m., Karen Reed calls Jennifer McCabe looking for John O'Keefe. Jennifer and Karen and another woman drive to John's house, right, the house where the party was, and then back, or no, to John's house, to John O'Keefe's house, and then back to the Fairview house, where then they find John O'Keefe in the snow. So when they had first gotten there, it was lightly snowing, but then I guess it snowed all night, and he's in the snow at that point. 6:04, 911 call reporting John O'Keefe was found in the snow. So as I'm looking at this, it seems like Jennifer McCabe is crucial to establishing for a jury what she saw and what happened that night versus whatever the defense is going to say happened that night.
Absolutely. She's not only crucial for the prosecution about what the state says she witnessed that night, but she is potentially crucial for the defense, because the defense claims that at something like 2:27 a.m., Jennifer Googles something along the lines of how long to die in the snow. And then they allege that she went and covered her tracks and then erased this search. At 2:30 in the morning.
Boom, right there. Why would you do, why? Why would somebody Google search that? Why? And delete it. So many deleted searches, so many phones being thrown away, so many upgraded phones, so many smashed SIM cards. It don't make sense.
No one has any idea that John O'Keefe is laying for dead outside in the snow. So why would she have any reason to Google such a thing? And then why erase it at a later date if that is in fact what she looked up? And here lies the conspiracy theory. Here lies, I think, the crux of what the defense is saying went wrong in this situation. And they say that John O'Keefe went into this party, that there was a fight, there was an altercation. He got into a fight with Jennifer McCabe's, allegedly with the owner of the house, her brother-in-law, that his dog got involved somehow, and that they all worked to cover it up.
Wow.
It's wild. I don't know what to
It's
think.
absolutely wild because both sides are so convinced of what they are arguing. I could see it in their eyes. I could tell sometimes when defense attorneys are, grain of salting it, nudge, wink. That's not the case here. These guys believe it from the prosecution's case report. The findings made during the autopsy in this case. Let's listen.
On January 31st, Dr. Irini Scortibello from the Office of the Chief Medical Examiner conducted the autopsy of Mr. O'Keefe. The doctor advised the troopers that she observed several abrasions to the victim's right forearm, 2 swollen black eyes, a small cut above the right eye, a cut to the left side of the nose, an approximately 2-inch laceration to the back right of his head, and multiple skull fractures that resulted in bleeding of the brain. Dr. Scortibello further advised the troopers that the victim's pancreas was a dark red color indicating hypothermia, was a contributing factor to his death. Dr. Scortibello opined from her examination that the significant blunt force trauma injuries occurred prior to Mr. O'Keefe becoming hypothermic, as evidenced by hemorrhaging in his pancreas and stomach. Mr. O'Keefe had arrived at the Good Samaritan Medical Center with a body temperature reading in the low 80s. The doctor opined that the extensive injuries to his head likely rendered Mr. O'Keefe incapacitated.
What does all that mean? Let's bring in our experts. We've got a great panel tonight. In Cope, South Carolina, expert witness from the Alec Murdaugh trial, currently Chief Deputy of the Orangeburg County Sheriff's Office. You recognize him, Dr. Kenny Kinsey of Kenny Kinsey and Associates. Joining us in Barrington, Rhode Island, board-certified forensic pathologist Dr. Priya Banerjee. In Jacksonville, Alabama, forensic death investigator, professor of forensics at Jacksonville State University, host of the very popular Body Bags podcast, Joseph Scott Morgan. And in Salt Lake City, Utah, retired police commander, host of Profiling Evil on YouTube, Mike King. Whew, great to see everyone. Guys, I'm just going to go ladies first. I'm sorry. We'll start with Dr. Priya Banerjee. We just went through these autopsy results. As you listen to them and you look at the results here, is it consistent with someone being struck as someone is backing up a car?
Well, I think, it really depends on the body conformation, the body position, but potentially that forearm could be a pattern from the car, from a car part. But I think really what it shows is that, that's not typical for a dog bite. Usually you have like the canine punctures and then small marks from the...
How about a canine scratch?
I still think that's less likely.
Gotcha.
I've seen various dog bites, and I think, if you mean canine scratch from his nails or from his teeth, maybe from the nails, but I still think they're too close together.
How about the multiple skull fractures? The multiple skull fractures.
That's really where the money is. That's the really most concerning part. The skull is not going to fracture without a significant impact. So whether he's hit somewhere else and falls and hits his head, or is run over and that's causing the skull fractures and the laceration, you're getting the black eyes from blood draining from the inside. It's not from being punched in the face. So really, we call those raccoon eyes. You see that, like it's a medical term where emergency personnel, anybody who deals with trauma knows, oh my gosh, this is a critical injury because there's a basilar skull fracture. So the base of the skull is crushed. It has, and all that blood's leaking down. That in and of itself is, can be lethal. Obviously, he survived a little bit for the rest of his body to be stressed in the cold weather. And those hypothermia findings are non-specific, like we see them, we don't. But all in all, I would have to agree that there was an element of hypothermia.
Joseph Scott Morgan, what does your gut tell you on the level of these injuries and the allegations here that there's a drop-off and then she backs into him with the right rear part of the truck? It's an SUV.
Yeah, this SUV, I think that it's significant. Also, you've got a broken tail light that's in play here.
Oh, we're going to get there. We'll get to the broken tail light.
I didn't mean to. I'm not intending to bury the lead here, Ben, but this is significant because one of the reports reads that he was holding a glass and that they found shards of glass that may have been embedded in the bumper. And back to the doctor's point just a moment ago, relative to these injuries that you're seeing, You know, one of the things that we look for in pedestrian strikes with motor vehicle accidents is we look for something called bumper marks. Generally, you see them on the leading edge of a car. If somebody is standing erect and they're trying to cross the street, one of the things that you see is that they're struck, generally around the knees, that sort of thing. Ben, he doesn't have any insults, it sounds like, really inferior to his hips. Everything is kind of taking place up above that. It would almost give you potentially the indication that he was in an asymmetrical position relative to this vehicle, with this vehicle potentially towering over him as she's impacting him. I think that that's kind of significant. And the scratches on the arms, I'm fascinated by this because it's cold weather, Vin, as you have well stated. He would have had layered clothing on, Vin. So this is not something, these injuries, I know the head trauma requires a tremendous amount of force, but this could very well be consistent with almost a rollover type event where the vehicle is running over him to generate this through a layer of clothing. However, we are absent one key piece here. We don't know how he was clothed at this point. So that's going to be significant.
That's going to be significant. All right. Let's take a look here, Dr. Kinsey. Evidence found near O'Keefe's body, okay? So he's in that front yard area. The snow has fallen down. As Joseph Scott Morgan was saying, they located a broken cocktail-style glass and multiple patches of red that appeared to be blood in the vicinity of where the body had been located. The Canton officers secured the glass and 6 blood samples from the snow as evidence. We also have to note that his cell phone was found underneath his body, not in a pocket, but loose and under his body. Dr. Kinsey, putting the pieces together that we have so far, what is it telling you?
Well, Vinny, I got to agree with the fine doctor and certainly the professor. Both of them have great points. And looking at those injuries on the victim, things I noticed was their uniform and they're very symmetric. I'm agreeing with doctor and professor. I believe we may have the victim down, and I would start looking for something under that vehicle that can make those injuries, because they don't look like an animal injury to me, and certainly they are uniform to the trained eye. So I'd start looking under that vehicle and see what kind of evidence I have, and maybe they have that. Maybe that's what they're banking on in this, but that is where I would have started.
Okay, let's take a look at the Lexus SUV, Mike King. They observed fragments of broken glass on the rear bumper of the vehicle. The rear right passenger side tail light was shattered, and pieces were observed missing from the red and clear areas. On the right side of the rear tailgate, a deep scratch and minor dent were observed. On the right side of the rear bumper, above a small red light, 2 scratches were observed, and one area where paint was chipped off. Does that sound like that could happen from striking and killing John O'Keefe?
Absolutely, and I think that's the elephant in the room that nobody wants to talk about, is the fact that there is physical evidence that supports that there was a collision between that vehicle and some object, and his body happens to have a whole bunch of damage to it.
The object was his vehicle that was parked, and it's literally seen on the Ring camera, her hitting his back, the back of his car.
Kid from the Utah mountains, Vinny. I know what it's like in the snow, and I know how easy it would have been for him to slip or fall and that car to roll under him, and I'm really looking forward to what forensics they might recover from underneath that vehicle. Doesn't look like dog bites to me, and it certainly fits the scenario, but they got to answer the elephant in the room. How did that broken glass get there? How did that cocktail glass get embedded in the bumper? How did that vehicle end up leaving the scene of an accident? Because I'm sure they're going to be able to compare that broken glass and that vehicle together.
All right, let me throw a little curveball at everyone when it comes to that right rear tail light. Here's Karen Reed's defense attorney showing another piece of evidence that they uncovered. Take a look.
The taillight was intact when she left Brian Albert's house. She came home, and this was Karen leaving to begin the frantic search for John O'Keefe. Now, I don't know that you can see it from the video that you have there, but there is no doubt that when that SUV comes into contact with what is John O'Keefe's vehicle parked in the driveway, you can see that rear tire move forward. It rotates, and you also see the light shatter from the taillight being broken.
All right. What do you think of that? So they've got at 5 a.m., so this is after the drop-off. She's already gone home. Now she's going back to try to find John O'Keefe. That's her story. She backs into John's car in the driveway, and we see John's car shake. Who wants this one? Who wants it?
The lights look uniform to
bat,
me.
Vinny. I don't see any glass.
I don't see any kind of physical disruption.
Okay, so you don't think that's what caused the damage here, Dr. Kinsey? You don't think so either?
No, sir, Vinny. That looked to me like bumper to bumper, and it was such low impact. I didn't, at least with my eyes, I did not see any broken taillight lens.
And you agree, Mike?
Yeah, I mean, I didn't see any glass fall into the ground there. And how are they going to respond to this? If forensically they tie that glass to sitting where O'Keefe's body is recovered, that's going to be a tall mountain to climb.
We shall see. All right, big thank you, Dr. Priya Banerjee. Appreciate your time tonight. The rest of the crew is staying with us.
Play a few minutes of that.
Through piece by piece tonight as we try to figure out.
I know the folks at work.
Just remind everyone about the cell phone use.
And how quickly can she get them?
She works extremely expeditiously.
Part.
Okay. Had in fact been
As much notice as possible, and my intention was to
You are unmuted.
And for the county of Norfolk. God need it. If your attendance, you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. You may be seated.
22117, Commonwealth versus Karen Reed. Can I have the Commonwealth identify themselves for the record?
Good morning, Your Honor. My name is Hank Brennan. I've been appointed as a special prosecutor for the Commonwealth.
Okay, so that's Hank Brennan, and he was hired by the district attorney to take lead in this case, which I have never seen done before.
Good morning, Mr. Jackson.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms. Reed.
Good morning, Ms. Little.
Good morning, Your Honor. David Yannetti for Karen Reed.
Good morning, Mr. Yannetti. Good morning, Ms. Reed. All right, so we have a series of motions here. I expect we may be here a while this morning. It makes sense to me to start with the Rule 17 motions. So the first Rule 17 motion I have is the Commonwealth's motion for records from Verizon. But I do have a question for you, Mr. Brennan. Have the third-party record holders been served in all of these Commonwealth motions pursuant to Rule 17?
Thank you, Your Honor. I understand the court might have a preference that I remove to the podium. Would you like me to answer?
It's wherever you're comfortable, as long as we can hear you.
Your Honor, I filed a series of Rule 17 motions, as I'm sure you're aware. I have not notified any of the third-party holders. I did not want to be presumptuous, seeing that I have not met the court and didn't know what the schedule would be for the Rule 17s.
Okay.
So I have filed these just to give everybody as much notice as possible, and my intention was to ask the court if we could set a date so that we could have these motions heard and hear the defendant's objections.
Okay. All right, so I misunderstood. I thought they were on for the Rule 17 motions today. All right, so the record holders do need to be heard. I was wondering why I did not hear from any of the parties, other than I have the defendant's objection to Mr. Reed's records. But all right, so we'll get a date, and that date should be sooner rather than later, to get notice out to all the parties.
Yes, Your Honor. I'll note that we did file 2 additional Rule 17s last night. I don't know if they've been docketed.
They have been docketed. I got them, and that's why I was wondering whether the record holders had in fact been notified. So, okay, so scheduling we'll do at the end of the hearing. Then I think what we'll start with, after these Rule 17s that we'll put on pause, it's paper number 48. It's the defendant's motion for relief from the order to impound sidebar conferences. And before we begin that, is there an opposition to that from the Commonwealth?
In part.
Okay. All right. Have you spoken with Mr. Yannetti about what part that is?
I've spoken to all of the attorneys numerous times. I think we're very clear what each other's position is.
Okay. All right, why don't you, all right, Ms. Giannetti, do you want to be heard by starting with the whole motion, or what?
I think we can short circuit this, Your Honor. Our suggestion, I think it's a joint suggestion to the court, is that the sidebar conferences be unsealed solely for counsel at this point. Mr. Brennan's at somewhat of a handicap because, unlike the defense team, he was not present at sidebar. He does not know what the conferences were about. And in fairness to the Commonwealth, we've agreed that it just be released to us, and then Mr. Brennan can decide if he has a further position regarding unsealing it more than that.
Okay. All right, that makes sense. Have you spoken with Ms. King about how long it will take to get these transcripts?
My co-counsel has spoken to her only...
Which co-counsel?
Mr. Jackson.
All right. What do you have to say about that? How quickly can she get them?
She works extremely expeditiously, but she has not started them. To my understanding, there's 3 reporters who probably would split the work.
Right.
And she said that she could get started as soon as there was a court order suggesting that she do so. I would imagine, given what we've gotten so far, we're talking a couple of weeks rather than a month or 2. I think we could probably get something within a few weeks.
Okay.
2 to 3, I would guess, just based on my experience with Ms. King.
All right. Even though it's just for counsel, do you intend to have, are you asking me to unseal the sidebar conferences with the jurors?
Just for counsel, yes. I would imagine that when we get to the second stage of this, those would be in a different category from the legal rulings at sidebar unrelated to jurors.
Somebody commented on my last video saying it looks like I'm throwing paper into my washing machine. This is not...
All right. All right. Thank you.
If I could be heard briefly.
Sure.
Thank you. Regarding the non-juror information, I'm in full agreement with the defense. I think it's prudent to, if the court would consider unimpounding the documents, I can review them.
Well, you can review unimpounded documents. Counsel can review impounded documents.
Then I'll begin that task, and if there's any concerns, I'll note them. If not, then I would have no concern about releasing them outside a protective order. The juror information stands in a different posture, in my perspective. I think that should remain impounded at this point. There's a pending appeal before the SJC based on the request of the defense. If they are successful, would then reinvigorate the attention on those jurors. I don't see a need for juror information to be unimpounded at this point. All the other information, I don't have the same concern.
Okay. All right. Thank you. All right, the next motion. So, defendant's motion for discovery of communications in the possession, custody, and control of the Commonwealth. Who's going to argue that?
I will, Your Honor. I would say at the outset that in speaking with Mr. Brennan, he had expressed a preference to be able to respond potentially in writing. So we were in agreement, subject to the court's approval, if we're going to get another date for the Rule 17 motions, to have this motion heard
at that time, but I'm prepared now if the court prefers me to.
No, I'll give you the opportunity. How much time do you need to respond in writing, Mr. Brennan?
I can respond by next week.
Okay.
Really, I'm accommodating the defense. I have a very broad perspective on Rule 14 statements. Our office has made a concerted effort to provide everything that's not only discoverable under the rule, but from my perspective, a broader perspective. I want to make sure I err on the side of caution and they get every statement they're entitled to. Okay. So we're in the process of accumulating all potential statements of witnesses which they're entitled to, and I'm going to provide them to them. I've already provided a number of statements that I frankly believe are outside Rule 14 parameters, and I'll continue to do that throughout this case.
Okay.
And so my response in writing really is to accommodate the request and then give an answer in a production of what I have. That's going to take me probably 10 days to put everything together, to adequately review it, and then to provide a package to the defense. And so I think that if I have 10 days, I might be able to accommodate the request without any need for litigation. If they decide to pursue further effort, then I can respond.
Okay. All right. So why don't we give you... So we give you until the 27th, just after, or just before the Thanksgiving break?
Appreciate that. Thank you.
Okay. All right. Does that work for you, Ms. Giannetti?
Certainly does.
All right. So let's talk about the Commonwealth's notice of scheduling, reassembly and testing of the defendant's Lexus telematics system.
May I?
Yes.
As a matter of background, as I think the court is likely aware, the Commonwealth tested information on data chips that were found in different modules that were inside the defendant's Lexus. Inevitably, at trial, the court is likely aware that there was information taken from one of the systems that was provided, and it showed information such as key cycles and different speeds. And I understand that was a exhibit at trial. There were two different search warrants by the government. One search warrant was for the car that included both a telestream and a telematics module, which is like a lunchbox with computer panels in them. And then in 2023, there was a second search warrant for the infotainment system, which is what was produced at trial. I hired an independent expert, and in the independent expert of the information, what he realized is that the information taken from the informatics manual and the information taken from the telestream manual had some irregularities. What he realized is that all of that data was unreadable. And so initially he thought that the data was not fully downloaded or compiled. He checked and he believed that gigabits were gigabytes and that there was a discrepancy. And the reason he thought this is because there was very obvious information missing from that procedure. There was information including navigation information, information regarding phones that were plugged into the radio, travel logs, things that are particularly relevant and material in this case, information that is going to be extraordinarily inculpatory or exculpatory in this case. And so after he realized his oversight on the gigabit, he filed a supplemental report. And what we learned is not only was the chips that were taken from the telematics and infotainment systems and downloaded were read with the wrong reader, so that way the information was not available. Also, in the the infotainment system, there were actually 3 boards, not 1. Only 1 was taken out. So there is a plethora of information on these chips that has not been downloaded that's relevant to this case.
Check this out. I'm going to show you how I afforded this car. Okay, you ready? All right, 100
And so we provided notice to the defense that our intention is that we are going to test this information that we have in our control and that we have a search warrant for. And my effort was to give them notice so they could have an available expert. So my purpose really was not to ask for the defense's permission, rather it was to notice them this is what we were going to do. You can see from my motion I asked to do it within 14 days. Having recently arrived at the case, it was important for me to prioritize Rule 17 motions and new experts so that they could have adequate notice. The defense asked for today's date and wanted more time, and when I considered it, I thought that was reasonable. I think they're entitled to have an expert and consider what we are doing, even though I don't believe they have standing to prevent it. And so that's why I agreed to this date. Inevitably, we know that this information will be on these chips. And so we know there are 2 boards on the system that weren't tested, and then the other chips that were tested that came back with unreadable information with the proper computer programs, they call them programmers, we will get viable information from both of them. And so I've spoken to the defense. I know they've hired an expert. I know they've filed a motion contesting our position. I'm not going to speak for what their position is today. But I would say 2 things. One, the defense in their motion asks to have their expert be able to intervene. We're not agreeable to that. They can watch and comment and criticize as much as they want, but we're entitled to the downloads. Notably, as first download is done, what we intend on doing, and the reason I brought it before the court is I wanted to expedite this matter. It's important, and it does.
I thought we were going to have that hearing within 14 days when we first got the motion, and then Mr. McDermott told me that the defense was looking for more time, so we gave this. But we're far into the case is scheduled currently for January 27th. Sounds like you have a lot to do before then, but as of right now, it's still January 27th. So all of these things, the Rule 17 motions, all of these things need to be done as soon as possible. So
I understand. And if I can just add, 'cause it might help in your consideration of a later motion. The reason why this is urgent to me to have this as soon as possible is because I also have noticed and hired an accident reconstruction expert. And that accident reconstruction expert will necessarily rely upon the information that is gleaned from this testing.
how long is this testing going to take?
It's a 3-day testing. It will take within a week to read it. And the sooner we have it, the sooner we can have our reconstruction expert engage in any type of task that we want them to. But they necessarily are in a holding pattern now. And that is my sense of urgency for this to be developed and done.
Who's arguing this for the defense? Okay, I'll hear you, Mr. Jackson.
Thank you, Your Honor. I'll start by saying, in principle, we don't have an objection to the retesting of the telematics or the infotainment center, our system data. The problem that we have, our issue, sort of dovetails into what Mr. Brennan was suggesting about what was done the first time. He just suggested that his new expert, Mr. Shannon Burgess, was astute enough to find something that Maggie Gaffney didn't find. Well, to bring the court completely up to speed, when the initial testing was done, the Commonwealth's expert did not know how to do a chip-off, physically did not know how to do it, the Joe Paul. He turned to Maggie Gaffney, our expert, who did know how to do it. She's a former MSP officer and extremely facile in this world of
And you
chips.
have a different expert now. You're not using her now?
Well, we may use her, but we have an additional expert who specifically works, Mr. DeSorga, specifically works in chip-offs and chip-ons. That physical procedure of moving chips on and off of boards. It's a very technical procedure. It's a very skilled procedure. He knows how to do it. He's got an extremely long resume, having done this kind of work.
I read it.
We're bringing him up to speed in order to sort of engage it in some oversight and some observation. I don't have a principled objection to doing the retesting. What I have a problem with is that their new expert, Mr. Burgess, right at the beginning, fundamentally misunderstood the data set on the 3 chips, the 2-micron chips and the expansion chip that he looked at, didn't understand the difference between megabytes and megabits, gigabytes and gigabits, and that gave us pause. If he didn't understand that, which is at the foundation of reading the data, we're concerned that some of the data could be destroyed in whatever process he engages in. Like I said, we don't have a principled objection to the work that's going to be done. We simply want to make sure that nothing is destroyed in doing that work. It's not, and I would take a little issue with something Mr. Brennan said, it's not that the data set is missing information. We don't know that it's missing information. Berla has now updated software that we suggest is that a process called a checksum can be done. I'm going to use some made-up numbers, but let's say there's 5,123 bits or bytes on a particular chip, you can do a checksum and determine that there's 5,123 bits and bytes read now. That means down to the bit or the byte, nothing has been altered, nothing's been changed, and we know that we're dealing with the exact same data set. That checksum would be the first process in doing the additional reading. Then they can go back and use the additional Burla software to see if the data set could be read. After that's done, then my understanding is there would need to be a chip on. They'd need to resolder those specific chips, the 2-micron chips and the expansion chip, back onto the motherboard, install the motherboard back into the truck, and then turn the truck on. That's the process that I understand. My only request is that our expert obviously, given his expertise and his knowledge of this information, he should be there to observe. And the only caveat to that is if he makes a determination, working with Mr. Burgess or observing Mr. Burgess's work, that what's about to happen is destructive to the data on the chips, we would ask gently, and I don't think this is much of an ask, that he be allowed to interpose his objection to moving forward, contact both counsel, both parties, and if need be, present his objections either to us to resolve it or to the court for intervention. That's all. I want the work done, but I want to make sure that the data set that is on those 3 chips or additional chips that are read is never destroyed or in peril of being destroyed. That's all.
All right. Any response, Mr. Brennan?
The defense expert would not be working with Mr. Burgess. He'd be observing Mr. Burgess. The defense expert has no active role in this testing. There is no inherent risk that Mr. Burgess is going to destroy something unnecessarily. This is potentially destructive testing, just as it was the first time. Fortunately, the information was not destroyed the first time, so we can access it again, but it's potentially destructive testing. The defense is not entitled to veto power during the process. That will delay things. It has no role and no purpose in it. And so, inevitably, Mr. Burgess is well qualified. Mr. Burgess is competent, and he is going to test these chips and provide the information to the defense. They'll get an exact copy. The idea of checksum, there's no mystery to these words. There's a protocol that's followed where they use the old software that was ineffective, and they test to make sure it's the same amount of data that's unreadable. And after they confirm that nothing has been moved or destroyed or tampered with, then they bring in the right programs, the right software, and they'll retest it properly. It will provide the information that will be available to both us and the defense.
All right, so if I act on this motion quickly, because there isn't a basic objection to it being retested, when can they begin, Mr. Brennan?
Your Honor, I spoke to my expert this morning, and I asked him for a schedule when he could test. I told him I'd like it as soon as possible. We didn't finish the conversation. What he told me is December 2nd or 3rd. I told him that would be inadequate. That's too far out. I want it done before Thanksgiving because time is of the essence, and I think it really develops everything else that will happen in this case as far as other experts. So I need to resume my conversation with my expert, encourage him, and insist that we make some changes in schedule. So I can't give an exact date because that conversation wasn't what I was expecting, but I don't think we can tolerate waiting that long.
Okay. All right, this one I will act on very quickly. All right, so I think that just leaves us with a motion to continue. I know it's a joint motion, but I need to hear from both sides.
Your Honor, the Commonwealth has been on this case for some time, and I am newer to the case. I'm not looking for a personal accommodation, but I think the idea of a motion to continue in our joint request is in the interest not only of justice, but I think inevitably, I truly believe it's going to have a more efficient and effective trial. A part of my perspective is to move as quickly as I can, and that's why I've started with the Rule 17 motions. I've also tried.
I do have to say, I do like him a lot better than Lally. He just gives me a better vibe.
I try to retain as many experts as quickly as possible. The experts will need to do whatever testing they're going to have and conduct, and then I need to provide the reports to the defense. The defense then may have counter-experts in reciprocal discovery that I want well in advance of trial. When I first entered the case, I was committed to January 27th, and I still am. If the court decides that's more appropriate, I will be ready on January 27th. However, I realized when I was trying to move and facilitate the testing of these chips in 2 weeks, and the government, the defense wanted more time, and I appreciated that their request was reasonable. I began to understand that it is going to take a little bit more time than I wanted to have the experts notice, the reports done, and then the defense have time to manage whatever the information is. I do not want to get into a position where we're turning over expert testimony, they're retaining experts to counter that testimony, and then to reciprocate in discovery where days, weeks, are in the midst of trial. I want to avoid unfairness to the defense at all costs, but I also want to avoid any unfairness for the prosecution, and that includes reciprocal discovery. And certainly, the reciprocal discovery cannot happen until I've provided everything that I intend on using. I have tried to exercise extraordinary diligence in this case. In addition to Rule 17s, and in addition to retaining experts, we have brought on my full-time paralegal, and we are going through the entire discovery. And I know it's already been provided, but it wasn't Bates' number, which I'm accustomed to. And we are re-indexing all the discovery and re-providing it, even though I expect most or all of it has been provided. And I'm doing that out of an abundance of caution so I can be confident that the defense has every document I have. That will resolve or prevent any delays at trial of inadvertent late disclosure or any concern or confusion about documents that have been provided. I also, with the office, have diligently moved to obtain all Rule 14 statements so that we can get the information to the defense as soon as possible. I've employed a practice when I'm retaining experts. I don't wait until we've done testing or reports. I immediately give the CVs to the defense so they can get started on investigating and looking into the experts. So nothing is held back when I receive it. If I receive any information that is discoverable or frankly not discoverable, I provide it to them. You can see in my discovery notices when I get emails from strangers with theories that I don't even agree to, that I don't know, I don't evaluate it, I give it to the defense. And so we're doing all of this to try to be as efficient as possible to avoid delays at the time of trial. And it will allow me, when I evaluate this case, which I'm still in the process of doing, of reducing the witness list substantially. And so although it does delay the case, if you allow this motion, I think it will make for a shorter, more effective, efficient trial, and I think it will be, importantly, more fair to the parties involved. And that's why I asked you to consider that continuance. I do not expect I would come before you and ask for another continuance. If something cannot get done in time with an expert of my choosing or that I would like, I appreciate I won't be able to use that expert. And so I think the joint request is something that is legitimate. I think it's well thought, and I leave it to Your Honor. Thank you.
All right. Who's going to argue this for the defendant?
I will, Your Honor. I'm not going to belabor the point. I mean, not surprisingly, in a joint motion, I agree with the argument made by Mr. Brennan. You've heard that there will be new Commonwealth experts. There are no reports yet. There have been no disclosures. No forensic testing has yet taken place. And the time frame, according to the motion, is somewhat unclear at this point. Clearly, once testing is complete, disclosures are made, we would have the right to consult with our experts and potentially employ additional experts depending on what the testing
Have you been working on that, though, in anticipation?
We have,
okay.
Yes. Mr. Brennan has promised to index all discovery so that both sides can be satisfied that full disclosures have been made. I know he's been working diligently on that. He needs a little bit more time to take care of that. I would remind the court that during the last trial, we were still receiving reports and some discoverable material as trial was ongoing, sometimes deep into a trial. And we're really trying to avoid that this time. It's really not fair to Ms. Reed that discovery is not complete well in advance of trial so that we can assimilate and incorporate that discovery into what would now be a retrial. And our position is, Your Honor, there's simply not enough time between now and January 27th to get all of that done and properly prepare for trial. And I would just close by saying that both sides and the court have an interest in having this matter proceed to trial expeditiously. But in our view, and I would expect in the court's view, the most important consideration here is Ms. Reed's right to a fair trial. And in light of what's outstanding and what needs to be done, we believe she would not be able to receive a fair trial at the end of January. We're essentially asking for a 2-month delay, which I believe is reasonable in light of what we've already discussed. We do not anticipate any further continuance requests, just like Mr. Brennan said. So we'd ask the court to allow this motion.
All right. What do you anticipate we need to do for in-court hearings? You mentioned in your motion, in the joint motion, a Daubert hearing. How many dates are we talking about? We already need a new date now for Rule 14, for the Rule 17 motions that we have. So we need to start moving forward with all of this. Is there going to be a Daubert hearing, and who is the witness that you anticipate a Daubert hearing on? I'd like to get that on our schedule now.
We have not yet drafted the motion, but I've given it much thought. The government at trial called an expert regarding a dog bite. Forgive me, I haven't watched all of the trial.
No, that's fine. All right.
That expert, I did not believe, followed the proper methodology or had the expertise to make.
All right. Does the defense intend to call Dr. I've forgotten her name.
Dr. Russell.
Dr. Russell, do you intend to call her again?
I expect that she will be out on this list.
All right. So why don't we set a Daubert hearing sometime in December? Does that give you enough time, Mr. Brennan?
It does, Your Honor.
Okay. So why don't we set a Daubert hearing? I know you'll have to fly her in, but why don't we get a date now?
You guys, I live in Florida and it is so fucking cold. I think it's like, it's 74 right now, which is cold for us. And I know I'm gonna get so much fucking backlash for this, but we're gonna be like in the 40s the next couple of days, but I'm already freaking cold. So if you see me just layering up when I come back from going pee, that's because I'm fucking cold.
So we're going to need
What's with that zoom in? What's with the zoom in on her stomach? The fuck? The fuck?
May I approach Mr. Brennan for a minute?
Sure. Jim, can you pull up Jimmy? How was it's December 10th? I think we moved both our trials yesterday.
Would the 13th of December be available for a Daubert hearing? It's a Friday.
Possibly. I think we just put something else on this morning that would be time consuming.
I could also do the 12th if Mr. Brennan's available, and in my co-counsel.
I was looking at the 10th, but Jim, could you look at the 13th?
Yeah, this is the 10th.
the 10th work for both of you. The government's available on the 10th.
So I have a, you cannot do the 10th, okay.
Your Honor, just to be completely candid, I have nothing on the 10th. I've got to fly out on the 11th, and I've got an all-day hearing on the 11th. So I'm sorry, I'm reversing that on the 9th. I need to fly out on the 9th, and I've got an all-day hearing on the 9th back in California, so I can't fly that day. So
well, court ends at what time?
I'm sorry, Your Honor?
You could take, a lot of people take a red eye, right? Can you come out then?
I do every time.
Look at Karen smiling. Judge Bev is a complete biatch to the defense, especially to Jackson. It's insane. If you notice that she continually cuts the defense off. Oh, Karen smiling. That's funny. Let's see if she yells at her.
You can't fly out on the 9th, the evening of the 9th?
There's no way I can't take a flight on the 9th.
What about the 16th? It's a Monday. Is that?
We're fully booked that Monday and Tuesday.
Okay. Let's stick on the 13th. Are we still on the 13th?
Sure, if it's available. Jim, we just put Gaston on for that day. Yep, we have a full competency hearing, and we also do on Gaston. About the 12th. Can you just look at that? Did you say the 12th?
The 12th works for all of you.
I can do the 12th.
I can do the 12th.
We'll accommodate, yes.
All right, so the Darbert hearing will be December 12th.
That'd be at 9 o'clock, Your Honor?
Yes. All right.
And those motions should be filed on the 27th.
We'll get a date on that in just a minute, Jimmy. When are you available for the Rule 17 motions? How about November 26th?
I have a trial that morning.
Where?
In Woburn District Court. To the extent that the court would give me a protective order, I can
Or tell them that you have a trial here, and if I need to speak to anybody, I will.
Okay, appreciate that.
We're not a trial here, but this motion hearing.
Okay.
I'd like to do it as soon as possible to get those out, get that moving.
Thank you.
So November 26th, Jim, can we do that in the morning?
Yes.
Okay.
I'm told that Mr. Jackson cannot make the 26th.
For the Rule 17 motions, do you need to be here in person?
If I could have 10 seconds.
During this moment, if I could just alert the court that there is one additional Rule 17 I'll have filed by Friday. It is similar to a number of...
File it and send notice immediately of the date.
I will.
Okay.
May I inquire, do I send notice on behalf of the Commonwealth, or does the clerk's office send it?
Mr. Lally can inform you on the process, but
Thank you very much.
send it right out.
We will.
Okay.
Thank you.
Is that okay?
Yes.
Okay. Yeah, we'll make the 26th work.
Great.
All right. That ends what I have for you guys for today on Karen Reed. I just made a few notes while I was listening to that. So the motions that seem to be going on during that hearing on the 13th was to unseal sidebars, something about her telematic system and Karen's Lexus, and obviously the continuance. That was for both of them. They both want that, defense and state, for April 1st of 2025. Upcoming hearings, we have November 26th at 10 a.m. and then we have December 12th at 9 a.m. So that's all for this one. See you in the next.
If you enjoyed this video, please like, subscribe, and share with some friends.